Good afternoon, everyone. Thank you for joining us for today's outreach session on the topic of the upcoming amendments to National Instrument 31103, National Instrument 45106, and OSC Rule 45501 with respect to trades and syndicated mortgages. My name is Adam Braun, and I'm a Senior Policy Advisor with the Investor Office Branch here at the Ontario Securities Commission. I am joined today by my colleague, Brendan Smith, Legal Counsel in the Compliance and Registrant Regulation Branch, who will be assisting me with answering any questions you may have on this topic. On that note, we ask that using this platform, you please send us your questions throughout this session as they come up. We will be answering as many questions as possible at the end of our presentation today. With that, let's jump into our slides. First and foremost, we would like to remind all attendees that today's presentation reflects the personal views of presenting staff and do not necessarily reflect the views of the OSC or any of our other staff. I also want to remind attendees that all information we present on today is only general information and should not be considered legal advice. For today's presentation, our session will be broken into a few parts. The first half of our session will discuss syndicated mortgages, which we may also call SMIs, and the substance of the amendments. The second half of our presentation, we focus on providing a high-level overview of the registration and compliance requirements for any firms that may be coming in for registration as dealers in order to trade SMIs going forward. This may also serve as a useful refresher for firms that are already registered as dealers. Finally, we will conclude our session by answering some of the most frequently asked questions that OSC staff have received on the topic of syndicated mortgages, as well as many questions as we can receive. And again, I ask all attendees to please send their questions in throughout the presentation. So first things first, what is a syndicated mortgage? As defined in securities legislation, a syndicated mortgage is any mortgage in which two or more persons participate directly or indirectly as a lender in a debt obligation secured by a mortgage. This is a fairly broad definition that can capture many types of mortgages. So in Ontario, we've also got two subcategories of syndicated mortgages: qualified syndicated mortgages, or QSMIs, and non-qualified syndicated mortgages, or NQSMIs. QSMI has a fairly detailed definition under the amendments. At a high level, it is defined in a way to limit its scope to mortgages that are lower risk and primarily residential property. These products are generally expected to be similar to conventional mortgages and exclude mortgages for financing, construction, and development, or any syndicated mortgage where the loan-to-value ratio, or LTV, is greater than 90%. For reference, LTV is calculated by looking at the total value of all the loans on the property against the current fair market value of that property. Non-qualified syndicated mortgages, on the other hand, are not defined, but they include any mortgage that does not meet the above definition of qualified syndicated mortgage. The reason for this distinction is important because in Ontario, trades in qualified syndicated mortgages will generally remain under the existing regulatory framework and continue to be overseen by the Financial Services Regulatory Authority of Ontario, or FSRA. Later in this presentation, we will go over the details of which types of syndicated mortgages will be coming under OSC oversight. So on this slide, I've included the fulsome definition of what is a qualified syndicated mortgage. I'm not going to read this entire definition now, but it's both here and in OSC Rule 45-501 for anyone who wishes to review this at a later date. So in the current regulatory landscape, I want to highlight that all mortgages are considered securities. However, in Ontario, the Securities Act says that trades in mortgages do not require a registered dealer or a prospectus, provided that the trade is facilitated by a mortgage brokerage that is either licensed or exempt from licensing in the jurisdiction where the property is located in Canada. So, for example, if you are brokering a trade for a mortgage on a piece of real estate in Ontario, as long as you are a licensed mortgage brokerage under the Mortgage Brokerage Lenders and Administrators Act, or exempt from that legislation, then these requirements in the Securities Act do not apply to you. The main change of the upcoming amendments, or incoming amendments, will be to modify this exemption such that it will no longer apply to trades in syndicated mortgages. As I mentioned earlier, certain exemptions to this are being brought in with OSC Rule 45-501, but the change will otherwise affect all syndicated mortgages. Finally, the amendments are expected to come into force in Ontario on July 1st, 2021. In other jurisdictions in Canada, these amendments have come into effect as of March 1st, 2021. Now, this presentation is focused on Ontario's amendments specifically, so we want to caution any firm that does or intends to trade in syndicated mortgages outside of Ontario to also review the legislation in those jurisdictions and consider the registration requirements there. So one question we have received from time to time is, why are these amendments happening? These amendments are coming into effect because we have seen a significant increase in syndicated mortgages being offered in Ontario, particularly with respect to those offered to retail investors. These offerings have raised investor protection concerns, especially as the features of these mortgages have more closely resembled traditional securities instead of conventional mortgage products. In addition, it was found that these products often were used to finance high-risk stages of development. Investors did not always receive full and fair disclosure about the features and risks of the investment or the current fair market value of the property. The substance of these amendments are designed to transfer oversight of riskier syndicated mortgages to the Ontario Securities Commission and to also build in additional protections for retail investors if they wish to invest in these products going forward. So, at a high level, these amendments do three things. First, as I mentioned earlier, they remove the existing dealer registration and prospectus exemptions from trades in syndicated mortgages in Ontario. After July 1st, if you are in the business of trading syndicated mortgages, you will need to be registered as a dealer or rely on a registration exemption such as those found in OSC Rule 45-501. Similarly, issuers will need to find a different prospectus exemption in order to distribute syndicated mortgages going forward. The second change is that where a syndicated mortgage is distributed under the Offering Memorandum Prospectus Exemption, also called the OM exemption, which is one of the few exemptions that is designed to raise capital from retail investors, then issuers will need to provide investors with additional documentation as part of the disclosure requirements. Most notably, issuers will need to deliver an appraisal of the current fair market value of the property and also make sure their offering memorandum includes all of the prescribed information in the new Form 45-106 F18. Finally, the amendments will prohibit issuers from relying on the private issuer prospectus exemption to distribute syndicated mortgages going forward. So I've referenced OSC Rule 45-501 a few times already, and I want to clarify what the exceptions are to acquiring registration as a dealer and prospectus in order to sell syndicated mortgages in Ontario. OSC Rule 45-501 states that there are still three exceptions for distributions of syndicated mortgages in Ontario after the amendments come into effect. First, any trade in a non-syndicated mortgage will continue to be exempt. Second, qualified syndicated mortgages remain exempt. Finally, trades in any syndicated mortgage to a permitted client will remain exempt. The term permitted client is defined in National Instrument 31-103, and while I'm not going to go through all the categories today, at a high level, it generally includes institutional investors, companies with at least 25 million net assets, or individuals with at least $5 million net financial assets. An important caveat to all of these exemptions is that it requires the firm trading the mortgage or syndicated mortgage to be licensed under the Mortgage Brokerage Lenders and Administrators Act as a mortgage brokerage and therefore be under the oversight of FSRA. If a firm is not licensed under this legislation, then none of these exemptions will apply. So to summarize the actual effect of the amendments on the existing exemptions for registration and prospectus requirements, this chart hopefully provides a helpful visualization of what is changing. If you are in the business of trading non-qualified syndicated mortgages with non-permitted clients, then dealer registration will likely apply, and any issuers raising capital from non-permitted clients for these non-qualified syndicated mortgages will need to find a different prospectus exemption to rely upon, such as the OM prospectus exemption or the accredited investor prospectus exemption, or any of the others that are set out in our legislation. Otherwise, your firm will likely be able to remain and operate under its existing regulatory regime. Now, this is a generalization. This is not a rule of thumb. I still encourage all firms to review the amendments carefully and speak with their legal counsel as necessary. The second major effect of the amendments is to provide additional requirements if you want to rely on the OM prospectus exemption to distribute syndicated mortgages. As I mentioned earlier, any issuer relying on this exemption will need to provide an appraisal at the current fair market value of the property by a qualified and independent appraiser. If the company is trying to develop a hole in the ground into a 20-story condo, then investors need to know what the current value of that hole is today, not what the condo is going to be worth if everything is completed perfectly. But to be clear, you are not prohibited from telling investors that you believe the condo will be worth a certain amount in the future. But that projected information may not be more prominent or pronounced than the valuation of the current fair market value. In addition, the appraisal must be delivered to the OSE with a copy of the offering memorandum. In addition, the OM must also follow prescribed disclosure requirements as set out in Form 45-106 F18. This will include information as typically included in the offering memorandum, but will also include information that is unique to syndicated mortgages, such as risk factors that are specific to this business, the administration of the mortgage, details on the property subject to the mortgage, information on the developers of the property, and any sort of conflict of interest that might exist between the mortgage broker, the borrower, the mortgage administrator, the developer, and any other parties. I want to highlight this last bullet point because we have regularly seen investor protection issues where the same minded management is behind both the borrower or developer and the mortgage administrator. In those cases, these conflicts have often led to firms having incentives not to act in the investor's interest, and it's important that these conflicts be properly managed, including clear disclosure to investors in the offering memorandum. Finally, the amendments make it such that the private issuer prospectus exemption will be unavailable for the distribution of syndicated mortgages. The private issuer prospectus exemption is intended for small businesses to raise capital, and we do not believe it is appropriate for this exemption to be used for products such as syndicated mortgages. While we understand this may cause some concern for issuers, other available prospectus exemptions, such as the accredited investor prospectus exemption and the friends, families, and business associates prospectus exemption, will remain available as alternatives to the private issuer prospectus exemption. So we don't believe this amendment will significantly restrict the range of potential purchasers available for syndicated mortgages. So this ends our summary of syndicated mortgages and proposed amendments. Before I continue with the second half of this presentation, I want to thank everyone who's been submitting questions so far and ask that you continue to please send your questions. As we've mentioned, we'll try to answer as many questions as possible at the end of this presentation. For the second part of our presentation, I'm going to first review at a high level the registration process for anyone who believes they will need to register as a dealer in order to trade in syndicated mortgages going forward. This is not meant to be a comprehensive guide for how to register, but I hope this will provide some signposts for what you need to be aware of in order to prepare your registration application. When a firm comes in for registration, there are a number of different categories of registration for which they can apply. With the removal of the dealer registration exemption for trades in syndicated mortgages, I anticipate that many firms that wish to begin or continue trading in syndicated mortgages in Ontario would want to apply for registration as an exempt market dealer, or EMD. This category of registration allows a firm to trade in securities that are distributed under a prospectus exemption, such as the accredited investor, OM exemption, or friends and family business associates exemptions that we've referenced earlier in this presentation. If you are coming in for registration for the first time, there are a few different systems that you should be aware of if you choose to register. The first is the National Registration Database, or NRD. NRD is a web-based system that permits registered firms to file certain registration forms electronically. All firms need to enroll on NRD in order to obtain an NRD number and submit certain registration application information. We've included their website here for ease of reference. The next form of importance is Form 33-109F6, which is the firm registration form. This form provides OSC staff with all of the relevant information about the firm so that we may assess its suitability for registration. Information required to be included with this form includes basic information like name and address, to more detailed information such as your business plan, organizational chart, audited financial statements, and other prescribed requirements. This form is submitted to the OSC for review through our electronic filing portal, and it is available through the link that, again, I've posted here for ease of reference. Finally, each individual that requires registration or that has a specific role called permitted individuals must file Form 33-109F4 through the NRD system. Registered individuals for dealers include the ultimate designated person, or UDP, the Chief Compliance Officer, also referred to as CCO, and dealing representatives, which we might refer to as DRs. These are the individuals who are authorized to trade in securities. The permitted individuals for a firm are the directors, the CEO, CFO, COO, and equivalent individuals, and any individual who directly or indirectly owns or controls 10% or more of the firm. Please note that an individual can be any one or all of these roles. It's not uncommon for some one-man shops to have one individual be the UDP, CCO, sole dealing representative, sole director, sole officer, and only shareholder. I want to spend a bit of time going over these individual registration categories, as the terminology may be new to those of you who are not familiar with this space, even though the underlying principles likely are. The first category is the ultimate designated person. This is generally required to be the CEO or equivalent of a registered firm. The UDP is the individual who is required to supervise all activities of the firm and its individuals, as well as promote a culture of compliance. There are no specific proficiency requirements for someone to be the UDP, but we expect a person in this role to demonstrate they are meeting these requirements and have a general level of proficiency, as well as the integrity and solvency to take on this role. The next category is the Chief Compliance Officer. For those of you who have operated primarily in the mortgage brokerage space to date, this position is similar to that of the principal broker. The CCO role is, of course, an important one, as it is their responsibility to establish and maintain compliance policies and procedures for the firm, as well as monitor the firm's compliance. The CCO must also have access to the UDP and the firm's board of directors or equivalent to provide reports as needed. Unlike the UDP, there are also certain prescribed proficiency requirements that a CCO must meet in order to be approved to act in this role. The requirements depend on the firm's category of registration, and all of the requirements are set out in National Instrument 31-103. Again, for the purposes of this presentation, I'm assuming that most firms applying for registration are applying as exempt market dealers, and therefore the most common route for proficiency would be for the CCO to complete the following three requirements. First, they will have had to have passed either the Exempt Market Products exam or the Canadian Securities course. Second, they'll have to have passed either the Partners, Directors, and Officers exam or the Chief Compliance Officer's qualifying exam. And third, they must have gained 12 months of relevant securities industry experience in the 36-month period before applying for registration. I'm going to speak more about what this relevant experience concept is on the next slide. The last registration category for exempt market dealers is the dealing representative role. Again, you can think of this role as similar to that of mortgage brokers and mortgage agents. Only the dealing representatives may trade in securities and conduct registrable activity, such as meeting prospective investors to discuss and promote securities, make recommendations, and assess the suitability of investments. I also want to highlight that the definition of trade in securities law is expansive, so it is important to consider who is conducting the trading activities to make sure everybody who needs to be registered is registered as appropriate. Like the Chief Compliance Officer, dealing representatives also have a proficiency requirement to be registered. Generally speaking, every dealing representative must have completed either the Canadian Securities course or Exempt Market Products exam. There are other options to be considered proficient that are set out in National Instrument 31-103, but I'm not going to go over those right now because they are a little more complex, and the most common route, again, as I mentioned, is to finish one of those other two exams. Now, I also want to spend a bit of time talking about the concept of relevant securities industry experience. Generally, Chief Compliance Officers need to demonstrate relevant compliance experience that has been obtained at a firm in the securities industry or that is securities adjacent, such as private equity or investment banking. However, we recognize that these amendments to syndicated mortgages mean that people who have been operating in the mortgage space as principal brokers or helping build compliance systems in the mortgage sphere for years or even decades are being brought into a regime that they have not generally operated in. As such, we're updating our guidance on what is considered relevant securities industry experience. And this is set out in the companion policy to National Instrument 31-103. In limited circumstances, OSC staff will consider that relevant securities industry experience may include experience obtained during employment at a firm that relied on a registration exemption. For example, experience obtained at a licensed mortgage brokerage may be considered relevant if the experience can be demonstrated to also be relevant for the category you're applying for. So someone who did compliance work at a mortgage brokerage and is now coming in to be the Chief Compliance Officer of an exempt market dealer to sell those same syndicated mortgages, we would likely consider that experience to be relevant. However, when these circumstances do arise, the OSC may also choose to impose terms and conditions on either the individual or the registered firm in order to limit their activities because their experience is limited. So for example, we might place a condition that limits the types of products that the firm can sell to only those that are mortgage-related products, such as syndicated mortgages or units of mortgage investment entities. So as mentioned earlier, the amendments come into force on July 1st, 2021. The OSC service commitment is to provide a decision on new routine business applications within 90 business days of receiving a complete and adequate application. I'm highlighting that last part because we have been receiving some applications from firms who are interested in trading syndicated mortgages that do not include all of the required information, which is delaying their approval. For anyone who still needs to apply for registration, we encourage you to apply as soon as possible and ensure your application is complete before submitting. In addition, please note that the OSC charges fees for the application of both firm and individual registrations, and there are fees for NRD as well. Please review the fees payable in OSC Rule 13502, as well as the system and user fees for NRD on the NRD website. In addition to the registration process, we want to spend a bit of time explaining our expectations of firms whose registration is approved. For those of you who operated in the mortgage brokerage space, many of these requirements are likely already familiar to you, either because of similar requirements in mortgage brokerage legislation or due to exposure you may have had with dealers who sold related products, such as mortgage investment entities. The two key overarching principles of compliance are set out in this slide. First, all registered firms must establish policies and procedures in order to comply with securities legislation and manage business risks. These policies and procedures form the backbone of your firm's compliance regime and help mitigate risks and concerns down the line. Second, all dealers must deal honestly, fairly, and in good faith with their clients. Even when there isn't a specific rule or law prohibiting or prescribing certain actions, this rule guides how we expect firms to interact with their clients. On this slide, I want to highlight a few obligations of registered firms. This is not expansive, and I encourage all firms to review National Instrument 31-103 in particular to get an understanding of your obligations. I also strongly encourage firms to regularly speak with their legal counsel or compliance consultants to ensure your policies and procedures remain up to date. The key obligation of registered firms is to know their clients, including their investment objectives, financial needs and circumstances, and risk tolerance. And as well, know your products, including the features and risks of what your firm is selling. Only with both parts of this information can your dealing representatives assess whether an investment is suitable for their client. For those of you who currently operate in the mortgage broker space, we are aware that this information is currently collected and documented through prescribed forms. I want to highlight a difference in the securities regime, which is that our requirements are principles-based. There is no prescribed form that you have to use to collect this information or document your suitability assessment. But you do have to document sufficient information to demonstrate that you've actually fulfilled these obligations. How you do that is something that you have some flexibility on. Another ongoing obligation is managing conflicts of interest. Firms must consider conflicts and avoid, control, and/or disclose them as necessary to manage the conflict. And please note that not all conflicts can be managed simply by disclosing them. Some conflicts, particularly where the investor's interest may not be acted on in their interest, are simply too great to be managed in that way, just by disclosure, and we expect additional actions to be taken. Dealers may also have a number of disclosure and reporting obligations to their investors. These include providing relationship disclosure information at the onset of the dealer-client relationship, trade confirmations when a trade is completed, and in some cases may also include ongoing account statements and annual reports on investment performance and costs and charges paid by the client. Finally, I want to remind firms that Form 33-109F6 and 33-109F4 must be kept up to date. Where firms change their ownership or their business plan, or individuals change what business activities they are doing, we need to be provided with an updated form to be given that notice. This is important to keep in mind because there are also late fees involved with late filings of these forms, up to $5,000 per calendar year or $100 per day, business day late. For our last topic, I want to also briefly discuss compliance reviews that are undertaken by OSC staff in our Compliance and Registrant Regulation branch. We provided an outreach session on this topic not too long ago that is still relevant, which we encourage you to review for more detail. For now, I just want to describe the two types of reviews we conduct. On-site reviews, or they're called on-site reviews, but in this day and age, they're mostly virtual, and desk reviews. On-site reviews are general reviews of a firm's compliance with securities legislation, while desk reviews are generally focused on a specific issue or concern, such as marketing materials or KYC information, as examples. Firms are selected for a review based on a number of factors, such as their risk ranking, time since last review, whether they fit the criteria for a focused review, etc. The factors involved mean that there's no set schedule for when a firm might be selected. However, if you are selected for a review, our website does provide information on what to expect and how to prepare. Please see the links in this slide for more information after our presentation. Finally, we want to respond to some of the more frequently asked questions that we've received since these amendments were first proposed. One of the most common questions we've received is, who is an issuer of a syndicated mortgage? We've included some guidance to answer this question in companion policy to National Instrument 45-106 to assist firms with this issuer. But at a high level, where a borrower enters into a mortgage, where a borrower enters into a syndicated mortgage or intends to syndicate the mortgage when they enter into it, they will generally be considered the issuer of the syndicated mortgage. Consequently, it's the obligation to comply with the condition. Consequently, the obligations to comply with the conditions of the exemption and the reporting requirements, including filing a report of exempt distribution, would fall on the borrower because they would be considered the issuer. However, there may be circumstances where a person other than the borrower may be an issuer of the syndicated mortgage. For example, where an existing or committed mortgage is syndicated among lenders by a party not acting on behalf of the borrower, that party will generally be the issuer of the syndicated mortgage. The determination of the identity of the issuer, or even issuers of a syndicated mortgage, will depend on the facts and circumstances of the transaction. And where the person other than the borrower is the issuer of the syndicated mortgage, I also want to note that the ability of the issuer to rely on the offering memorandum of exemption for the distribution of that syndicated mortgage will be very dependent on whether the issuer is able to provide information regarding the borrower, the original borrower, such as the financial statements. It's very important because the offering memorandum of prospectus exemption has prescribed requirements, and the issuer has to certify that the OM does not contain any misrepresentation, which includes information about the borrower under the syndicated mortgage. Another question we've received frequently is, why is an appraisal required for syndicated mortgages? The reason for this is we need to see an appraisal that discloses the fair market value of the property and that doesn't take into account any sort of future proposed improvements or proposed developments. The fair market value as it currently exists is important information for prospective purchasers to understand the protection afforded by their security interest in the property subject to the mortgage in the event there's a default by the borrower. I spoke earlier about the example of a hole in the ground, the valuation of that hole in the ground compared to that of the completed condo project. It's important that investors understand their exposure and risk by investing, especially where their investment is being done at the early soft cost stage of a development project. Another question we've received is from firms who are coming in for registration for the first time is, how do I hire a chief compliance officer? Now, again, as I mentioned earlier, we understand that firms that have operated only in the mortgage space for years may have difficulty finding a CCO who meets the typical relevant securities industry experience requirement. As I mentioned earlier, we've added new guidance in our companion policy to National Instrument 31103 that clarifies that CSA staff will be open to considering CCO registration for a firm that sells mortgage products in a securities regime where that individual can demonstrate relevant compliance experience obtained at a mortgage brokerage. And again, this might restrict the firm to only being able to sell mortgage-related products, but it is certainly a path that we are open to and will consider if those cases come in. We do review these applications on a case-by-case basis, so each situation will be unique, we acknowledge, and we are happy to have those discussions. Finally, we received a question from some individuals who've said they have been in the mortgage business for a number of years, 10, 15, 20 plus years. Do they really need to write the exams to become a CCO or to become a dealing representative? So first of all, we do have an application process where through NRD you could apply for exemptive relief from the examination requirements. However, I will say that the time and cost involved to make such an application will likely outweigh the time and cost of completing the exams. If there are extenuating circumstances, you could theoretically apply and we would consider it, but please be aware there's no assurance that we will grant exemptive relief. Finally, to end this session, I want to highlight a few resources for everyone to review that we have referenced throughout today's session. The first three items, National Instrument 31103, National Instrument 45106, and OSC Rule 45501, are the instruments and rules that are being amended. We encourage everyone to review these items as well as their companion policies for information on the rules and guidance to assist with their implementation. I also want to highlight National Instrument 33-109, which provides information on the registration requirements for any firm or individual that believes they need to apply for registration. So finally, I want to thank everyone for their time this afternoon and for sending in your questions. Before we answer, we're going to take a 5-minute break and then we'll return. Thank you.